Welcome to this explainer. Look, today we are unpacking a massive shift in how the justice system operates. We are diving deep into the newly drafted AI governance principles for the judicial system. If you've been wondering how courts plan to handle the absolute explosion of artificial intelligence, well, you're in the exact right place. We're going to decode these incredibly dense, newly proposed regulations to figure out what the future of legal tech actually looks like. And we need to do it fast, because the deadline for public comment is right around the corner. Okay, let's quickly run through our roadmap for today. We're going to cover 1. The AI judge myth. 2. Human primacy rules all. 3. Transparency and accountability. 4. Bias, data, and privacy. 5. Innovation versus restraint. And finally 6. The future of legal tech.
All right, starting right off with Section 1, the AI judge myth.
Will AI completely replace lawyers and judges? I mean, it's the question literally everyone is asking right now. And honestly, it's not entirely baseless. We recently saw Albania famously appoint an AI as a minister. Plus, major publications like the Economic Times have run articles basically suggesting companies should adopt AI specifically to eliminate the quote-unquote army of lawyers usually needed for compliance. With all that momentum, it's completely natural to wonder if human judges are the next ones on the chopping block.
But here is why we really need to separate the hype from reality, and fast. The number 20, specifically June 20th. That is the hard deadline for the public to submit comments on these draft rules from the Supreme Court. There is very little time to study this, making it absolutely critical that we quickly digest what's actually being proposed before these foundational rules are permanently locked in. Which brings us to Section 2, Human Primacy Rules All. The core philosophy of the draft regulations is actually pretty simple. Section 4 categorically shuts down the whole robot judge idea. The exact text dictates that AI shall at all times remain strictly subservient to human judgment. It explicitly states that AI systems are only going to function in an assistive capacity. They absolutely cannot supplant or even compromise the independent exercise of judicial authority by a human officer. As the author of our source material points out, this strict limitation acts as a surprising but totally mortal blow to anyone predicting an immediate AI takeover of the courtroom. If you are holding your breath for an AI judge to hand down a verdict anytime soon, well, you can go ahead and exhale. This regulation officially shuts that argument down once and for all. Human beings are keeping the ultimate authority over matters of law, fact, and justice. Period.
Moving right along to Section 3, transparency and accountability.
So if humans are entirely in charge, how does the justice system handle the inevitable technical mess-ups that AI makes? The draft regulations definitely don't pretend AI is perfect. They specifically target major technical pitfalls. Take hallucinations, where an AI just confidently makes up incorrect information. Or black box systems, where the AI operates so opaquely that not even its own creators can explain its decision logic to the public. The rules mandate that deploying these kinds of opaque systems will face intensely heightened scrutiny, especially in high-risk applications that could mess with a person's personal liberty. Which leads to a massive, highly practical question. If a judge or a legal officer uses an AI tool, and that AI hallucinates a completely fake legal precedent or makes a palpably incorrect recommendation, who actually takes the blame? Does the judge just get a free pass because the tech glitched out? The answer is a hard no. The human officer is exclusively accountable. The regulations make it explicitly clear that a human cannot invoke the opaqueness of a black box system or blame an AI hallucination as an excuse. If a human uses AI to make an illegal or harmful decision, that human takes the fall entirely, the whole shebang. Any AI-generated output used in court is treated strictly as advisory, and it absolutely has to be verified by the human in charge.
All right, Section 4, bias, data, and privacy. With accountability sitting squarely on human shoulders, we have to look at the strict guardrails placed on the actual fuel for these powerful systems, the data. These regulations are deeply concerned with privacy. They mandate rigorous data protection, ensuring AI is used solely for the approved purposes it was designed for. That's a concept known as purpose limitation. They also require data minimization and privacy by design, all perfectly in line with the Digital Personal Data Protection Act of 2023. And critically, sensitive judicial data has to be given the absolute highest standard of protection, backed by incredibly robust cybersecurity.
Now, ensuring data integrity requires a really strict, step-by-step approach. The draft demands that AI be trained on accurate, representative, and lawfully obtained data. Furthermore, it explicitly prohibits deploying AI that might perpetuate any kind of discrimination. Special care absolutely must be taken so these tools don't introduce bias against vulnerable groups, whether that's minorities, persons with disabilities, or folks from economically disadvantaged backgrounds.
Next up, Section 5, Innovation versus Restraint.
So all of those rules sound very responsible, but it brings us to a really fascinating crossroads. If you read Section 17 of the draft, it actually claims to champion innovation over restraint. It says courts should actively encourage the integration of AI to reduce delays. But, and this is a big but, the author of our source analysis argues that when you look at the sheer mountain of rigid rules, the continuous audits, and the human-in-the-loop mandates, the exact opposite is true. Restraint actually overrides innovation.
So why the huge contradiction? Well, the source analysis suggests this overly rigid approach actually stems from a place of fear. It seems the draft authors operated under a genuine panic that AI might quickly overwhelm the formal judicial system and eventually eliminate human adjudication entirely. It turns out even judges get anxiety about being replaced by software. And as a result, the courts have been far more restrictive than they probably needed to be.
Finally, Section 6, the future of legal tech.
Where does all this leave us? The reality is, our courts are still facing absolutely severe delays. Because the formal judicial regulations are wound so tight, the source suggests that legal tech innovators should pivot. They are actively encouraged to deploy AI in alternative dispute resolution spaces, specifically in mediation and with recourse arbitration processes. These specific areas shouldn't be nearly as heavily stifled by the rigid formal court rules, which provides a real testing ground for AI to actually improve efficiency today.
As you wrap up this explainer on these foundational draft rules, we're really left staring at a delicate balancing act. On one hand, protecting human rights, ensuring fairness, and keeping a human in the loop is absolutely vital for justice. On the other hand, courts are literally drowning in backlogs. So what you should take away from this is one final pivotal question. Will these highly rigid guardrails successfully protect the integrity of our justice system, or will they simply hold back the desperately needed innovation that could finally make access to justice fast and efficient for everyone? It's a massive debate that is going to define the future of law. Thanks for tuning in, and keep questioning the systems being built around us.